Right now, though, we're going to talk to Stuart Rudner, is an employment lawyer at Rudner McDonald here in Toronto. Stuart, thanks for taking the time tonight.
Oh, thanks for having me on.
Not at all. The story is that the idea of internships and what they do and what they get paid or not may be changing. And this all comes around a movie called Black Swan, which you may remember from a few years ago about the... obviously you do.
I do, yeah.
Yeah, and it was a good movie, actually. Fox Searchlight Pictures put it on, and they had a couple of interns that they didn't pay. And what happened, that's not unusual. The interns sued, and a ruling came down from U.S. District Judge William H. Pauley III that suggests that they should have been paid. Now, this is something that's it's a time-honored tradition, and maybe more so in entertainment business than anything else. But the idea of internships and not being paid for them, it's nothing new, correct?
Not at all, and it's something we all know about. We all assume that if you're an intern, you don't get paid. But it's one of these misconceptions about what it really means to be an intern. And I look at this case, and obviously I'm no expert in American law, but I read the decision, and their analysis is pretty similar to what you would see in Ontario, because they really focused on the fact that what these quote-unquote interns were doing was really no different than what a paid employee would have been doing. The advantage was the employer, who was getting the benefit of their labor without paying them, and there was no real aspect of training or education which would be required for a true intern.
So that's what we have to define then, right? We have to define what, in this particular case or in others, actually incorporates learning and not needing to get paid for it. In other words, what these guys did, as the judge suggested, it was taking jobs from someone else that they didn't have to pay for. So how do we know where the internship ends?
That's a perfect question. And if you look at the Employment Standards Act in Ontario, they start off by saying that an employee includes a person who receives training from the employer. So by default, an intern is still an employee. And if you want to be exempt, they actually lay out 6 conditions that you have to meet in order to be an intern. And I'll run through them really quickly.
Yeah, please do.
Condition number 1 is that they have to be receiving training similar to what they would get in a vocational school. Number 2 is that the training has to be for the benefit of the individual, not the organization. Point number 3 is that the person providing the training derives little, if any, benefit out of the training. Point number 4 is that the quote-unquote intern is not displacing an employee. Point number 5 is that the individual is not basically guaranteed a job at the end of the training. And then point number 6 is that the individual has to be told up front that they're not going to be paid. So really the 2 key points that I take out of that is that the benefit has to be for the individual, not for the organization.
Right.
And that they can't just be displacing a paid worker.
But they have to also be told beforehand they're not getting paid. I would imagine that's pretty much across the board. Everybody knows that, correct?
Well, I think everyone knows that. And I think where you get into trouble is, and this is not unlike many employment law issues, just because both parties agree and sign a contract saying, I'll be an intern and I won't be paid and I'm perfectly happy with that, doesn't mean that's legal, and doesn't mean if you're challenged by a court or in a court that you won't be found to be breaching the Employment Standards Act.
Is it essentially the same as, say, a job placement would be? Would that be an internship?
Well, that's a perfect example. If you really want to be comfortable that the Employment Standards Branch is not going to look into this and question you, you want to have an intern program that is like a co-op, that is either organized or at least sanctioned by a school. That will demonstrate that it is for educational purposes and not just so you can get free labor.
Okay, I guess I understand that. There does seem to be some value to that, though, to the employer. Is there not?
There can be. And I think most employers would say that they do get some value, although it's also an investment in time, if not in money, because you are supposed to be providing training that you would not provide to a regular employee. So while there may be some benefit, and if you look at the Employment Standards Act, it says there should be little, if any, benefit to the organization. The bulk of the benefit is supposed to be going to the individual.
Okay. I should ask you, Stuart Rudner's with us, an employment lawyer at Rudner McDonald LLP here in Toronto. Do you find that, or do you hear about abuses here about internships? Is it because I would guess, and maybe I'm wrong on this, but I would think if an intern feels he's being abused, it would be unusual to take that next step, like these 2 gentlemen did in the movie, to actually sue, because the concern you would have is I'm never going to get a job in that business.
Exactly. I think most people would call that a career-limiting move.
Yes, exactly.
So you're absolutely right. I mean, most people who are in that situation realize that it's something they're going to have to deal with if they want to get a job in the industry. That being said, I found in the last month, putting aside the Black Swan case in the States, there have been a lot of articles in the news and claims being made or threatened by people who have been called interns and not paid, and they realize that really that they should have been paid for the work like any other employee.
When you say a lot more of them, does that mean it has been a problem all along? You're just seeing a greater number of them lately, or is this a new phenomenon?
No, I think your first point is right. I don't think anything has changed. I think, if anything, public has become more knowledgeable. You go online, you can read about these things, and as soon as you read a case like the Black Swan one, you'll have people who say, you know what, I'm in this quote-unquote internship position, but really, I'm no different than the guy down the hall who's being paid for his work.
Yeah, well, listen, in the radio business, it happens all the time. We have interns all the time, and it isn't fair a lot of times. I wonder what would happen if this was policed a little bit better. I'm not sure which. I would imagine you're probably on both sides of this issue. With some people that you're representing, how do you feel about that? What would happen if, in fact, people started, bitching and moaning a little bit more?
Well, undoubtedly. I mean, the Employment Standards Branch or the Ministry of Labor, they always pick areas that they want to focus on and do their inspections on. And if there's enough noise made about a certain issue, then they will start to look into it. And, perhaps this will become the next issue that they deal with. Right now, or up until now, it's really been below the radar.
We're speaking with Stuart Rudner, an employment lawyer here in Toronto at Rudner McDonald LLP. The story we're referring to is actually south of the border, having to do with a couple of interns who thought they were wronged during the making of the movie Black Swan. And one of the other things, Mr. Rudner, that was mentioned in this, and I'm kind of curious what you think about this, the suggestion is made, at least in the article I saw, that we're maybe seeing more of this and the potential for abuse of the use of interns simply because the economy isn't doing that well. Have you seen that, any indication that that's the case?
Absolutely. And I can look at that through the eye of the legal industry. Right now, it's becoming very hard for students who are graduating from law school to get their articles. And what we're seeing now is that they are basically saying they'll work for free because, of course, they have to article before they can be called to the bar.
Right.
So you'll have lawyers who say, well, here's a chance to get some free labor. And, there's all kinds of rules that apply there from the Law Society, which is not, which is different than the typical employee. But the concept is the same. The market or the economy has gone down, jobs are scarce, and employers will then be a lot quicker to take advantage of free labor.
And that is something, especially in the law business. I know my daughter just went through that, as a matter of fact, and she has some friends in the same situation. It is tough to find articling jobs. So many people are graduating from law school. How many do you think actually decide not to study law, to practice law, because they can't article? Is it a sizable percentage, you think?
I'm sure there is. I mean, I can tell you this. I'm on the board of directors of the Ontario Bar Association, and so we've had a lot of discussion about this. And the last statistic I heard was that 20% of graduating students cannot find articles. So 1 in 5.
Does the Law Society actually police whether they're getting paid as they're articling?
You know what, to be honest, I don't know. I mean, I know that there are rules about what you can and cannot do as a lawyer or principal with an articling student, but I'll say this, I know that there are many articling students who are not being paid.
I really appreciate you taking the time tonight.
Well, thanks for having me on.
Stuart Rudner with the Rudner McDonald LLP, an employment lawyer. It is an interesting question.